Peace, everybody. Peace and blessings. I got some good information for you guys, and I would like to share it. So let me share my screen so I can share what I have to share. Ladies and gentlemen, let me show you where we are and how am I going to do that. Let's see if we can minimize. Yeah. Okay. I have several law dictionaries, as you can see, of which I spend a lot of time going through. But I would like to bring you to a particular subject called pleading. Please. I'm going to take you into Black's Law 8th edition, which I already have on the screen here. And I believe we're going to go to 3560. Let's start it there. Page 3560. Does pleading start there? Maybe not. Pleadings, patents. Had this set up for you guys. I apologize. 3565. Hold on, let me go to my notes. Oh, 36. That's why. Let's go to 3660. Make it 59. Black's Law Dictionary, 8th edition, 3659. And we still didn't get to the first page. Okay, it's actually 3658. My apologies. Pleading. Pleading, it's a noun, a formal document in which a party to a legal proceeding, especially a civil lawsuit, sets forth or responds to allegations, claims, denials, or defenses. In federal civil procedure, the main pleadings are the plaintiff's complaint and the defendant's answer. Cases, Federal Civil Procedure 621, pleadings. Corpus Juris Secundum Pleadings 2-3, 6-7, 593. Accusatory pleading. Oh no, we're not going to read those. My apologies. So, pleadings. When you are brought into a court or you are served a summons citation, you are asked whether you plead guilty or not guilty. When I dug deep into this information, it led me to a peculiar spot because I was under the impression that you are innocent until proven guilty. So not guilty and guilty is still pretty much guilty. It's either not guilty or guilty. So it's guilt. I'd rather plead innocent if you caught that. There is no such thing as not innocent and innocent. It's you're innocent until proven guilty. So when you make a plea on those forms or you make a plea in writing and you say, I am not guilty, shouldn't you be writing that you are innocent until you can prove my guilt? Okay, let's keep going. So anyway, in seeking more information on pleadings, it brought me to this particular series of definitions. And the first definition that we're going to come across is pleading the Baby Act. Pleading the Baby Act. Let's go. Where's my file at? Where's my file at? Okay, here we go. Pleading the Baby Act. What is Baby Act? It's a plea of infancy, interposed for the purpose of defeating an action upon a contract made while the person was a minor. Is vulgarly called pleading the Baby Act. By extension, the term is applied to a plea of the statute of limitations. Any contracts that you made when you were a minor. Now, they don't define minor in this term because it could mean you were under 18, perhaps under the age of 21, or you were legally incompetent. So I plead the Baby Act. I was legally incompetent to make that, to sign that contract or get into that agreement. Pleading the Baby Act. Okay, let's keep going. Where's my, here we go. Plead the Baby Act. You know, plead the fifth, we're familiar with that one. Then we came up to plea and avoidance. Let's see what plea and avoidance is going to do. Plea and avoidance. And that's here. Let's close the Baby Act. It's called a plea and confessions and avoidance. A plea that is an answer to a plaintiff's charge that gives them the right to sue, but the cause of the action is discharged by a subsequent matter. Plea of confession and avoidance. Can you use any of these pleas that we've gone through so far? Perhaps. See, if you don't know about it, you can't use it. If you know about it, you can perhaps use it at a later time when it's convenient. Now, I am from the school of you never offer a plea. However, criminal charges were never levied against me thus far for me to have to decide what I would plea or not plea. However, I know you do not want to join in to their circus, to their play, to their performances, unless you're being duly compensated. So I don't think I would ever take a plea, but they say never, right? So moving right along. We got a plea and bar. Let's check out what plea and bar is. Closing these out. Plea and bar. An answer given by the defendant which completely defeats all actions, charges levied by the plaintiff. Plea and bar. Now, I am not racing through this stuff, but I kind of sort of am. Because I do not want to make these videos long. I just want to present this information to you and get you on your way of studying and looking up these things for yourself, because I can explain this to you to the best of my ability, you know, using my opinion and my understanding of these matters. But how will that help you? You need to do your own research. I think I say that on every video, and I hope you're getting tired of me saying it, because I'm getting tired of saying it. But you must do it. You have to do it. You can call me for assistance, and you can call me for advice. You can write me, text me, email me. And, you know, my thing is to point you in the right direction or to help give you some clarity and guidance. The dot connector, you know? but it pays when you do your own and you call me up and we bounce ideas off one another. I really appreciate that. I like when people do their own study and say, you know what, I read this and, I came across it like this and, my understanding is this or my understanding is this. And so far, a lot of the conversations are matching up because I feel the same way you feel on the matters that you bring to my attention. So, plea and bar, an answer given by the defendant which completely defeats all actions. It completely defeats all actions and charges levied against the plaintiff. Powerful, powerful information if you're going to use it. Plea and bar. And we continue on. We did the plea and confession and avoidance. What about a plea and discharge? Let's check that out. Get rid of this. Plea and bar. Plea and discharge. A plea where a plaintiff has the right to sue, but where the defendant has already fulfilled all of his obligations to a plaintiff. A plea and discharge. You can sue me, but you ain't gonna get much. And let's get to the next one. I'm not sure if I pulled up the plea and estoppel, but let's check that out real fast. And we did. See, I choose, so let me go back there. I stay in Black's Law or the lawdictionary.org. Let me go to another, punch it in for you. I usually like to go to Google. I have several search engines, but when I do these videos, I like to go to the easiest ones that you're familiar with. So we're gonna go to Google. And in the search column, not right now, in the search column, let's do it here. We're going to put in the lawdictionary.org and it's going to come up. This is where I usually do my initial definitions of words. And if I'm not comfortable or if I'm not content with the answer that I get, then I go and I rely on my beautiful law dictionaries. All right. So going back, that's Black's Law Dictionary. I believe that's the second edition. And we were going to the plea and estoppel. Now, looking for the plea and estoppel, it did not come up in the law dictionary or the lawdictionary.org, one of the site that I just showed you. So we're going to read some of the definitions that come up when you just do a regular search of the term. Let's go to right here, the law.com. An estoppel is a preclusion in law which prevents a man from alleging or denying a fact in consequence of his own previous act, allegations, or denial of a contrary tenor. Okay, estoppel. Estoppel, we're going to do that definition for you as well, but I'm going to give it to you. Estoppel is when you had an opportunity to speak, but you failed to do so. So in your administrative process, when you contact these people and they fail to answer you in a timely manner or fail to answer you, efficiently, they are more or less stopped after you complete your administrative process. Meaning they had a time to answer, now they can't answer, so you get a default judgment against them, and they can't say nothing. They can't wait until now you get the default judgment and say, oh wait, I know, stop, you're stopped. All right, so a plea and estoppel is basically stating that, okay, the defendant had an opportunity to defend his or her actions and failed to do so. So they should not be allowed to actually continue with the defense. There is no defense, or they had an opportunity to defend, but they, are stopped. Got it? So now let's go back to the law dictionary, like I said, and is this Bing? not too fond of Bing, but let's just run with it right now. And we're going to put in estoppel, and it should say exactly what I just told you. Maybe it won't. Let's see. Estoppel. What is estoppel? A bar or impediment raised by the law, which precludes a man from alleging or denying a certain fact or state of facts in consequence of his previous allegations or denial or conduct or admission, or in consequence of a final adjudication of the matter in a court of law. Case sightings, and we're going to go right here. A preclusion in law which prevents a man from alleging or denying a fact in consequence of his own previous allegation or denial of a contrary tenor. An admission of so conclusive a nature that the party whom it affects is not permitted to aver against it or to offer evidence to controvert it. Estoppel is that which concludes and shuts a man's mouth from speaking the truth when a fact has been agreed on or decided in a court of record. What is a court of record? Interesting right there. Paperwork. Neither of the parties shall be allowed to call it in question and have it tried over again at any time thereafter, so long as the judgment or decree stands unreversed. And when parties, by deed or solemn act in pies, agrees on a state of facts and acts on it, neither shall ever afterwards be allowed to say a fact so agreed on, or be heard to dispute it. In other words, his mouth is shut, and he shall not say that this is not true, which he had before in a solemn manner asserted to be true. Okay? Estoppel. His mouth is shut. So, where's my law dictionary? Okay. Plea and estoppel, plea and suspicion, plea and pure. I think we was gonna, plea and release, good one. Plea and not pure. I believe that's gonna be similar to the plea of release. Let's do some searching. Right here. So we're gonna get rid of this, get rid of that. Plea and pure. What is plea pure? A plea that will introduce new material for the defense, such as a plea for a release when a debt has been paid. That is the basis for the suit. If you are being taken to court for non-payment of rent, and you subsequently pay that rent the day of the court date, the case is dismissed. Why? Because the initial cause of action has been completed and there is no more controversy. So a plea that will introduce new material for the defense, such as a plea for release when a debt has been paid, that is the basis. That is the basis for the suit. Okay, plea pure. Now, we're going to end this video with this last one because it's such a big one, and I hope you guys are paying attention. I hope you guys are paying attention. There is so many more. Plea of tender. There's so many pleas. Plea of action, plea of declaration, so many more. This is Black's Law 8th edition. We're on page right now 3662. We're going back to about 3661. Nope, we're going 662. Is it 66? Yeah, 661. And I want to show you a plea of release. Secure party creditors or secure parties, please stand up. Why would I say such a thing? Let me show you. Plea of release. We're going to the law and legal definition. Plea of release is a plea that admits the claim, but sets forth a written discharge executed by a party authorized to release the claim. Plea of release. That is in the law and legal definition. What is a plea hearing? Release and detention of criminal forms. Plea and release. Okay. I had the definition up for you, and I must have closed it by accident. Plea of release. Okay, so at this point, I am going to read a statement to you, of which you can pause and write down what I'm saying, read it over to yourself, get familiar with it. When secured party individuals, especially appear in court, there are words and phrases that are used that conform with a plea of release. And it goes as such. Now, this is one term. You can find others, you can make your own. So if you have to, again, pause this video to write the stuff down, I urge you to do so. You step into a courtroom and attendance is taken. You know, I'm here on special appearance. State your name or don't state your name. You know, I am here for that matter, what have you. And when you get an opportunity to speak on the record, for the record, and let the record reflect. I am here in honor, by special visitation, to settle this matter and bring account to zero. I demand someone step forward, state a claim upon which relief can be granted, and exhibit an invoice for my acceptance in return. I am prepared to offer up my private exemption as a one-time good faith offer of performance in exchange. In exchange, I demand a zero balance settlement statement, a release order, and a full discharge of the administrative tribunal showing that I have satisfied any and all outstanding liabilities due and owing in the public. Would the administrator prefer to settle this matter privately in chambers? That would be a question that you ask. All rights reserved, without prejudice, without recourse. Had you gone through a secure party process, maybe you're interested or curious about a secure party process, this will be the culmination of what you're hoping to do and complete. You are the creditor. You have the exemption, you have the credit, of which they would like to use, and they must get your approval and your opinion, unless they're going to circumvent and they're going to, ravage your account without you knowing. If you don't know any better, they're going to take advantage of you. But when you know better, you will release the credit and you are absolved from responsibility. So going over it one more time, please pause the video, write this down, and get to know these terms, because you never want to go into their arena and argue. There should not be a controversy. There should be an agreement. If you don't have an agreement before you go in there, you need to offer up an agreement while you're in there. And you can do so by offering to settle. I'm not here to dispute. I'm not here to challenge. I'm here to settle. So again, the term or the phrase or the sentence is, I am here in honor by special visitation to settle this matter and bring account to zero. I demand someone step forward, state a claim upon which relief can be granted, and exhibit an invoice for my acceptance in return. I am prepared to offer up my private exemption as a one-time good faith offer of performance. In exchange, I demand a zero balance settlement account or settlement statement, a release order, and a full discharge of the administrative tribunal showing that I have satisfied any and all outstanding liabilities due and owing in the public. Would the administrator prefer to settle this matter privately in chambers? All rights reserved, without prejudice, without recourse. This has been the Bud-Brownsville LLC presentation. Parent company, Marshall Enterprises. I thank you for your time. I thank you for listening intently. I thank you for clicking like and subscribing. You are all appreciated, and I hope someone can use the information that was disseminated. Be well, stay blessed. Bud Brownsville out.